G'day, I'm Dr. Matthew Rimmer. I'm talking about plain packaging for the Pacific Rim, tobacco control and the Trans-Pacific Partnership. In my talk today, I am going to look at big tobacco, those pirates of public health, and their efforts to hijack the Trans-Pacific Partnership and undermine critical tobacco control measures such as graphic health warnings and plain packaging, and sap the strength out of the World Health Organization Framework Convention on Tobacco Control. Now, to begin with, I guess it's useful to think about the contradictions that are at the very heart of the Obama administration's approach to tobacco control. So I thought it would be useful to begin with President Barack Obama, who's overcome being a smoker himself, signing the Family Smoking Prevention and Tobacco Control Act, which kind of contained graphic health warnings as part of its measures, emphasising that kids today don't just start smoking for no reason, they're aggressively targeted as customers by the tobacco industry. They're exposed to a constant and insidious barrage of advertising where they live, where they learn and where they play. Saying that, introducing graphic health warnings as a kind of a critical measure to address the tobacco epidemic. At the same time, alas, the United States Trade Representative has taken a rather ambivalent perspective on the question of tobacco control as part of the Trans-Pacific Partnership. So I'm kind of fundamentally concerned about this kind of paradox that you have Obama on the one hand promoting the need for graphic health warnings to deal with the tobacco epidemic, and on the other hand this kind of backsliding that's been taking place in the Trans-Pacific Partnership, particularly in relation to allowing lobbying by the tobacco industry under the shadow of darkness, pushing for TRIPS double plus agenda in relation to intellectual property, calling for very strong investment clauses, and also pushing for text on tobacco control which is quite limited. Now, I guess a great deal of concern has been expressed by the way in which tobacco companies have tried to use trade agreements to undermine tobacco measures, and Peter Drahos earlier gave a great introduction to that topic. There's a long history of that happening. In relation to the TRIPS agreement, we have British American Tobacco's internal memos in which they said, well, we should rely upon trade agreements to try to frustrate plain packaging, with the right that they thought they would have little joy in running that kind of particular route. British American Tobacco made submissions to the anti-counterfeiting trade agreement, pushing a tobacco agenda in that context. And in the Trans-Pacific Partnership Agreement, you've had a push from a variety of tobacco companies, most particularly Philip Morris. Philip Morris in their submission on the Trans-Pacific Partnership emphasised that Philip Morris is becoming increasingly concerned about government-sponsored initiatives that would effectively cancel or expropriate valuable trademark rights. It supports the inclusion of a comprehensive TRIPS Plus intellectual property chapter that includes a high standard of protection for trademarks and patents. It went on to say that trade restrictive legislation regulations of the type currently being considered by several countries within the Trans-Pacific Partnership ignore the rights of trademark holders under domestic legislation, as well as the obligations of those countries under the TRIPS agreement. Implementation of those measures would have serious implications for all intellectual property rights holders. Such legislation may also be in violation of the TBT agreement. So you can see here the tobacco industry very clearly want to raise standards on IP, investment, questions in relation to technical barriers and trade above and beyond what is found in relation to the World Trade Organization. And unfortunately those submissions have been supported by a very vociferous lobby, both within the trade bodies advising the United States Trade Representative. So if you have a look at the industry advisors, they include such people as Clyde Wayne Jr. of Tobacco Associates Incorporated, Roger Quarles of the Burley Tobacco Growers Cooperative Association, pushing inside the trade forums for tobacco-friendly positions. And in the United States Congress, you've had delegations from Kentucky, and North Carolina and elsewhere pushing on the question of tobacco. So the Kentucky delegation, for instance, made a very crude, slippery slope argument that the exclusion of tobacco would lead to the exclusion of other products, such as alcohol and dairy products. Excluding tobacco from the TPP would establish a broad and possibly economically debilitating precedent, potentially applicable to any industry. So the lack of transparency surrounding the Trans-Pacific Partnership has been exploited by the tobacco industry. Laurie Wallach of Public Citizen has said it very well. Think of the Trans-Pacific Partnership as a stealthy delivery mechanism for policies that could not survive public scrutiny. And I think that point is a very strong one. The lack of transparency, due process and public participation in the Trans-Pacific Partnership has allowed the tobacco companies to flourish in terms of pushing for measures that would undermine tobacco control measures. In my talk, I just want to kind of pick up some of the key areas. I have a kind of a 70-page version of this, but I'll briefly kind of have a look at the key areas to be concerned about. As Deborah Gleeson kind of pointed out, there is a huge problem with the extreme agenda being pushed in relation to the intellectual property chapter of the Trans-Pacific Partnership, in relation to tobacco, but also in relation to other areas that might be affecting health. Well worth remembering that the tobacco industry have relied upon multiple forms of intellectual property rights. So they've relied upon trademarks, but they've also relied upon things like patents, designs, get-up, copyright protection. So they've tried to assemble a wide array of different intellectual property rights associated with tobacco packaging and labelling. I guess the challenges in Australia against the plain packaging of tobacco products have very much been focused on trying to use those array of intellectual property rights to challenge the legitimacy of government regulation. So JT, Japan Tobacco International, and British American Tobacco, together with Philip Morris and Imperial Tobacco, mounted a kind of a constitutional challenge against Australia's plain packaging regime on the grounds that plain packaging amounted to an acquisition of property on something other than just terms. The majority of the High Court of Australia rejected that challenge. The decision is kind of very important because it recognises that governments can make use of health warnings and health labelling to deal with regulatory issues. The High Court of Australia, particularly Chief Justice French, citing amongst others Peter Drahas, kind of emphasises that intellectual property law is intended to serve larger public interests and larger public policy purposes. So the High Court of Australia said that trademark rights don't provide you with any kind of crude monopoly. They provide particularly tailored rights to serve larger public interest objectives across all the various areas, and they don't allow you to ignore other forms of regulation. And the case is also kind of quite interesting in the way in which it deals with the constitutional question, in which it says there was no acquisition of property in this particular case. The Commonwealth Government did not acquire trademarks or any other intellectual property rights by asking for plain packaging in this particular case. It's a critically important decision, not only for plain packaging of tobacco products, but for a wide range of other issues in relation to intellectual property and public health. I think it's critically important that the Australian Government defend and protect both the plain packaging regime and that significant important decision by the High Court of Australia. In the World Trade Organisation, Australia has been under attack by various countries, including the Ukraine, the Dominican Republic, Honduras, and most interestingly of all, communist Cuba has ganged up with the capitalist tobacco industry to challenge health-loving Australians' plain packaging regime, which is a very kind of curious collaboration. The Trade Minister Craig Emerson, after the plain packaging decision came out, very clearly and very fundamentally kind of highlighted that it was the sovereign right of Australia to protect the health of its citizens, and he vowed that he would fight to defend plain packaging in a variety of different forums. So I think those disputes are very important to think about as we think about the Trans-Pacific Partnership. There is great concern in relation to the position of the Department of Foreign Affairs and Trade in relation to the Intellectual Property Chapter, both because the Department has promoted the Anti-Counterfeiting Trade Agreement previously, which had no proper tobacco control recognition in terms of that agreement, and there was a lack of adequate consideration of questions in relation to access to essential medicines. According to US Inside Trade, the position of the Australian government in the IP debate in the Trans-Pacific Partnership has been pushing an ACTA model in the Trans-Pacific Partnership. As Deborah pointed out, the position of the United States government is even worse. They want a kind of a double plus regime in relation to the intellectual property chapter, and that would be deeply disturbing in relation to thinking about intellectual property and public health and tobacco control. So just to wrap up, talking questions about investment, questions about tobacco control, and also about debates about technical barriers to trade. I'd just like to wrap up and kind of say that the Trans-Pacific Partnership, in terms of how it's being contemplated at the moment, in terms of the intellectual property chapter, the material in relation to investment, and the language that is being used on technical barriers to trade and tobacco control are alarming because they don't necessarily recognise the primacy of the World Health Organization Framework Convention on Tobacco Control. And there's a great concern that the United States has taken a very narrow vision of tobacco control based on battles over graphic health warnings and have not really recognised the primacy of this multilateral framework on dealing with the tobacco epidemic. So I think it's critically important in thinking about questions of tobacco control to ensure that trade agreements are supportive of the World Health Organisation's efforts to deal with the tobacco epidemic and also support the use of measures like graphic health warnings and like plain packaging. Lauren Huber has kind of noted that responsible trade policy acknowledges what we've known for decades. Tobacco is a uniquely dangerous product that causes death and disease from ordinary use. Tobacco is not just another agricultural product that deserves promotion through US trade policy. It is the target of the world. The World Health Organisation's first and only treaty recognises the devastating effects of tobacco and its increasing threat to global health and welfare. Including tobacco in the Trans-Pacific Partnership Agreement would undermine the success of this treaty in preventing tobacco-related disease around the world. And I just want to finish by saying I think it's critically important that we have plain packaging for the Pacific Rim, and other countries follow the olive revolution of the Australian government and adopt plain packaging and graphic health warnings. And it's critically important that the Trans-Pacific Partnership is not used as a means by big tobacco to make the Pacific Rim Marlborough country. Thank you.
So I'm just going to briefly in the 10-minute slot try and highlight some of the areas where the TPP raises some particular concern areas in terms of trying to tackle the nutrition and NCD problems that the world is facing, really. So just to reflect back that we know that NCDs are the leading cause of death globally, and the disability life-adjusted years, which is the sort of burden of disease. The last analysis now shows that while the overall burden attributable to nutritional deficiencies has declined, which is good, less nutritional deficiency, the role of nutrition and diet still dominates the top 20 risk factors, largely due to the link between poor nutrition and non-communicable diseases. So we now have in that top 20 list of the key causes of disease burden, nutrition from undernutrition and also from overnutrition as well. And the reality is that tackling these problems is extremely hard, requires multi-pronged actions, and in particular there's a need for policy and environmental level interventions if we're really going to start to tackle these huge problems. So what I'm going to do in this presentation is draw on the latest draft of the Global Action Plan for the Prevention and Control of NCDs. So this hopefully will be ratified at the World Health Assembly at the end of this month, and the latest draft of that plan is now available and includes recommendations for actions at the country level on diet. So this is mainly around NCDs, but a lot of them are relevant to undernutrition as well. So this is pretty mainstream recommendations that have been developed, and they've been somewhat perhaps watered down over the process of consultation. So they're not really fringe activities, they're pretty mainstream. What I'll try and do in the next few slides is highlight how even what I'd consider fairly mainstream activities may be negatively impacted or unpractical under the TPP. And just reflecting back as well about what we've discussed earlier, the TPP is quite different from existing trade agreements, which Anne-Marie has spoken about earlier, and the perhaps negative impacts of some of those on diets. And of course, this is just based on the leaked text. So one of the recommendations in the global strategy, the draft, the global action plan rather, is that the countries should implement the WHO recommendations to control the marketing of foods and non-alcoholic beverages to children, including mechanisms for monitoring. And the concern around this is particularly with regard to the chapter that deals with cross-border services. Now, while the similar chapter in WTO allows for measures necessary to protect human health, at the moment there's no exceptions included within TPP, and so this may limit the scope to actually regulate the industry, because the reality is that cross-border advertising is the way that the food industry wants to go, because it's much more advantageous to them and much more low cost. And similar to the issues that Matthew was just talking about with the IP, there may also be some concerns raised from the chapters on intellectual property and the use of trademarks that may also limit the potential for governments to act on this area. The next issue of concern is that one of the other recommendations in the action plan is to provide nutrition labelling for prepackaged foods, particularly those which have nutrition or health claims. There's evidence that we need consumers to be able to make informed choices about the processed foods that they buy with appropriate, understandable labelling. And this needs to include both ingredient and nutrition information labels. And ingredients, of course, is also of relevance to food safety. And one of the proposed annexes, which Deb mentioned earlier, may actually restrict these options in terms of not allowing for quantities of ingredients to be included. And while quantities aren't necessarily included at the moment, things like caffeine are normally labelled, and increasingly other potential allergens are also labelled as well with the actual quantities. So this may limit the scope to actually target those areas. So that limited space may prevent governments from even attempting to pursue advanced labelling laws. Another recommendation in the action plan from WHO is to promote the provision and availability of healthy food in all public institutions. This is talking about school food guidelines, guidelines around about hospital meal provision, even prisons and so on. And one of the chapters in the TPP around government procurement is designed to require a more open tendering process, so anybody from any country in the world can apply to run the school canteens if it wants to. And because there's a need for less conditions within that requiring tight nutritional standards, even things like wanting to source foods locally, may actually have some problems and may be objected to by companies that are trying to put in a tender for this. So governments may feel that they're no longer able to put in those really tight healthy eating guidelines around meal provision which they provide. Another policy recommendation is that there should be policy measures directed at the agriculture sector to provide greater opportunities for the utilisation of healthy local agricultural products and foods. And as highlighted earlier, there's evidence that foreign direct investment can be quite negative in terms of this sourcing of local foods because of the dominance of the large manufacturing companies. So there may be less control over the agriculture sector, and because of this requirement for more open direct investment and the possibility of more land grabs with overseas companies or even countries purchasing or renting land in other countries and then using that to promote their own food security while negatively affecting the food security in the land in the country that they're accessing the land from. So overall, it may limit the space that governments have to act in this area. Another recommendation in the Global Action Plan is to develop guidelines, recommendations or policy measures that particularly target food processors or operators, for example, through regulatory approaches restricting the use of trans fatty acids, which are, almost in the same league as tobacco in terms of no level of safe consumption. So again, this requirement for more open access for foreign direct investment may reduce the space for governments to actually try and implement these policy measures, and in particular may contribute to this increased access to the processed foods, which tend to be the problem foods in terms of the ones high in trans fat and so on, and may limit the space that governments have to try and reduce the levels of the harmful ingredients in those products. And also within this, there may be some concerns around the need to have food industry around the table during discussions about food policy recommendations, and I'll come back to that. A related measure, so one of the chapters on regulatory coherence is that there should be the opportunity for industry to be involved in government policy making. So they would have the opportunity to intervene, and not to intervene, but to make their recommendations and comments felt throughout the government policy making cycle. And to a certain extent that's already there, but this requires it and gives industry a much greater role and perhaps power at the table, and is of concern because the reality is that food industry will make more money by value adding, which value adding for food industry means more processing, which allows them to make greater profits on products. And unfortunately, greater processing normally means increased levels of fats, sugars, salts, and trans fats particularly. A related recommendation in the Global Action Plan is to develop policy measures aimed at food retailers and caterers to improve the availability, affordability and acceptability of healthier food products. So again, this requirement for greater openness for foreign direct investment may mean that there's less control over the influx of global retailers and fast food chains into countries. So you'll perhaps no longer be able to say, well, we don't want fast food chains in a certain perimeter around schools, because there will be this open access for them if they want to come in. And even within hospitals, which I know is always a subject of debate about whether or not fast food chains should be in hospitals, but this in essence would perhaps say that no, you can't restrict that. They're allowed to go where they like. It's part of the open access. So the ability to control where these retailers and fast food chains are may be difficult, and it may also increase the problem of food deserts, where you go to a certain suburb or area and there's really only unhealthy foods accessible rather than there being a range of choices accessible. Another area is around state-owned enterprises. One of the chapters focuses specifically on this in the leaked text. And what this may do is prevent governments from attempting to control any distribution of food. So, for example, in some areas where there are remote areas, remote populations, then the government may actually be making sure that foods are accessible to that community at a lowered price, or controlling the stores to make sure that a range of foods is available, because there would be an open requirement for them to operate at the same level as private company, i.e. still be able to make the same amount of money. It may make that wider range of foods less accessible in those remote locations as a result of that. The other areas of concern that seem to be popping up are, again, around this investment and investor-state dispute. The possibility of the restrictions on controlling advertising, labelling and so on. Also that overall what we're attempting to do within health promotion is change what people eat. We want them to eat less fat, sugars and salts, and change the types of products that they purchase, and that therefore has to have an impact on food industry if they do not change the types of products that they make. If you're just making unhealthy products and our health promotion is working, then yes, you are going to have less sales. And at the moment, there seems to be an implication in the TPP that as a result, that company may be able to sue the government and say, well, look, you've affected our sales, and therefore we've lost out as a result of that, although they haven't adapted as a result of the community changes. So that raises some concerns as well. The other issue is that because of requirement to create cross-border consistency, there's a need to perhaps lower standards. So this has been raised in the US, concerns about the fact that their food standards, their food safety standards, may need to be lowered because they will need to bring the bar lower so that all of the countries will be operating on the same level. So even people in the US have expressed concern around that one. So overall, there is potential for a lot of concern areas within TPP. It really depends on how those words are framed exactly, and there is scope for none of these things to happen with the appropriate framing and with the exceptions for health being included in there. So, but overall, the ability of industry to sue governments could be a major disincentive for action and could create this regulatory chill. So we do need to bear those things in mind. As I mentioned, the things that I've just gone through are relatively mainstream core activities, and I think the potential that TPP may actually restrict the option to do those is of great concern.
I did ask Sharon if I could swap my presentations around and have half an hour to talk about medicines and only 10 minutes for the introduction, but she wouldn't let me. I could talk for the rest of the day about medicines, but I'll try and get it over with fairly quickly. So I'm basically going to just take you on a whirlwind tour through 3 areas of the TPP that will have an impact on access to medicines in Australia and the other TPP countries. There's a 4th area as well, which is an annex to the technical barriers to trade chapter, but I won't have time to talk about that today, but I just wanted to flag that. Then I'm briefly going to talk about Australia's position in relation to medicines and some of the issues for developing countries. Just before I get into the TPP, I'll just give you a very, very brief background about trade agreements, intellectual property rights and medicines. And of course, there's a huge literature on this topic, and people like Peter Drahos have been studying this for a very, very long time. And I can't possibly cover it all now, but just to point out that the World Trade Organisation's TRIPS agreement was the first trade agreement that included intellectual property and included minimum standards for intellectual property, including 20-year periods for patents. But the TRIPS agreement also allowed for flexibilities and safeguards so that countries could actually protect public health. And those safeguards and flexibilities were reinforced in the Doha Declaration in 2001. Since the TRIPS agreement, we've seen the expansion of intellectual property rights through successive trade agreements, particularly those negotiated by the US and the EU. More recently, in US trade agreements, we've seen attempts to influence the pharmaceutical coverage programs of US trading partners. So the first attempt was through the Australia-US Free Trade Agreement, and there was a subsequent attempt in the agreement between the US and South Korea that was far more successful for the US, that is. So with the 2011 US proposals for the TPP that I mentioned earlier that were leaked, there is a set of more extreme provisions and in a trade agreement with developing countries. So this is a very big issue of concern amongst access to medicines activists and organisations. Now, Sharon has actually banned me from talking about this slide. I'm not quite sure whether she thinks I'm going to bore you all to tears or whether I might spend the next 2 hours talking about it. But I will just mention two things. So there's a whole set of different mechanisms in the intellectual property proposals put forward by the US for the TPP that would extend monopoly rights for pharmaceutical companies. And I'll just mention two of those. Again, there's a big literature on this topic. And for someone who hasn't read anything about this before, probably the best place to start is MSF's issue brief on the access to medicines and the Trans-Pacific Partnership Agreement. So one of the provisions, the one at the top there, patent protection for new forms, uses and methods of using existing drugs. That enables pharmaceutical companies to get extra patents for minor modifications to existing drugs. So this encourages evergreening, which of course already happens in a lot of countries, including Australia. But what this provision would mean is that countries can't reduce or prevent patents for being granted for minor modifications. Also, another one I just want to point out is this issue of data exclusivity. Data exclusivity is where manufacturers of generic drugs can't rely on the clinical trial data produced by the originator to actually register their products. In Australia at the moment we have 5 years of data exclusivity and most if not all of the other TPP countries. But the US is seeking to extend that to 3 years, an extra 3 years for new indications of existing drugs, so new uses for drugs that are already out there. And the big pharmaceutical companies in the US are seeking 12 years of data exclusivity for biologic drugs, so very extended periods there. They also want that extended in scope to cover data that's already in the public domain. So even if something's actually being published in the literature, a generic drug company wouldn't be able to rely on it. So this, all of these provisions put together extend significantly the intellectual property rights for pharmaceuticals. And in each of these areas, the proposals are more extreme than the already high levels of intellectual property protection that we have in Australia. And they're much higher than the levels in some of the other TPP countries. So the mechanisms through which those intellectual property provisions would have an effect are in extending the duration of patents, making them easier to obtain. Medical procedures, diagnostics and treatment methods would be able to be patented. Patents would be more difficult to challenge. And the overall result of this is that it would delay the market entry of generic medicines. And of course, generic medicines are far less expensive than patented medicines. And this is particularly important in developing countries. So if the US proposals were adopted, we'd see higher costs for governments, health services and consumers. And as I mentioned in the earlier presentation, when the costs of medicines go up, it's vulnerable groups who are most affected and also people in developing countries. Now, around the same time that the US made these proposals for very extreme intellectual property rights in the TPP, they also tabled a white paper called Trade Enhancing Access to Medicines, or the TEAM paper. which was framed as a new strategic initiative designed to deploy the tools of trade policy to promote trade in and reduce obstacles to access to both innovative and generic medicines. So this was supposed to solve the problem of access to medicines. The core of this proposal was what's become known as the TPP access window, which was a requirement for innovators to bring medicines to market within a certain period of time in exchange for these strong intellectual property protections. And the period of time wasn't specified. So the problem with this is that access to medicines is being equated with the availability of new patented medicines, and completely left out of the picture are issues of coverage and affordability. So there's really no point in bringing new patented medicines to market earlier in developing countries if they're completely unaffordable for the people who need them. So I think what this made very clear was that what this is really about for the pharmaceutical companies is market access, not access to medicines. So I'm going to move on from intellectual property to just take a look at the annex to the transparency chapter of the TPP. So this includes wording that precludes therapeutic reference pricing, which is a very important strategy in our PBS and New Zealand's Pharmac for keeping costs down. In the US proposal, there's an appeals process that could challenge recommendations for listing and pricing of medicines, and a set of onerous obligations for disclosure and what's called transparency, which is quite ironic really when you consider the TPP as a whole. There's also a provision mandating direct-to-consumer advertising of medicines via the internet, and we know that that can interfere with rational prescribing, and in fact it's not allowed anywhere except in the US and New Zealand at the moment. So what this would mean for Australia and New Zealand that have pharmaceutical coverage programs are reduced government control over medicines policy, new avenues for pharmaceutical industry influence over decision making, higher costs to government and consumers, or in New Zealand where they have a cap on pharmaceutical expenditure, there could be more restrictions on access, and the sustainability of these types of programs would be threatened. Developing countries wouldn't be immediately affected because they don't have these types of schemes already, but there'd be restrictions on their ability to introduce such schemes in the future. They wouldn't be able to do that in the best way possible. But the most outrageous thing about all of this is that this would probably have no impact on pharmaceutical coverage programs in the US. So they're actually carved out. It's framed in such a way that it only applies to schemes at the central level of government, which of course the US doesn't have. Just to flag also that the investor-state dispute settlement process that we've discussed earlier could potentially, depending on regulatory and judicial arrangements, could be used to challenge formulary listing and pricing decisions, or reforms to pharmaceutical policies and regulatory processes, or even decisions about patents. And there's been Eli Lilly, a pharmaceutical company, recently issued a notice of intent to use the investor-state dispute settlement process under NAFTA to sue Canada for $100 million for revoking a patent. So the existence of the mechanism alone might be enough to undermine evidence-based formulary decision-making. I think we've talked a bit about the Australian government position already. I just wanted to point out the trade policy statement from 2011, which has a specific commitment around continuing the pharmaceutical benefits scheme. But there's a big question mark around what that means, and whether it might be, whether there might be some problems with accepting provisions that may not affect the ability to continue it, but may affect its effectiveness. I don't think I've got time to talk about anything else. I need to finish up. Okay, all right. So Australia's current position, which has been maintained to date throughout the negotiations, is probably likely to result in reasonable outcomes for Australia if it's maintained. But the developing countries remain very much at risk, and the Public Health Association and the other NGOs concerned about access to medicines in Australia have been continuing to try and get this issue on the agenda, that Australia needs to be thinking not just about the appropriate arrangements within Australia around access to medicines, but also about the other countries in the agreement. Thank you.
I'm going to start with the proposition, and that is that all international trade agreements, by design, are intended to shrink domestic policy space. Certainly acknowledge and endorse Professor Drahouse's point this morning that in practice their actual effects are indeterminate. By design, they're meant to shrink domestic policy space. They're here to try and solve the international collective action problem and trying to coordinate policy across borders in order to increase economic integration and trade. That general proposition, I think, applies even more strongly or keenly in the case of the TPPA. I think we've heard from both Deb and Anne-Marie today that really persuasively shows that in the design intent, we're about shrinking domestic policy space. What does this mean for policy making? In a sense, it moves policy making away from domestic political institutions, from constitutional government, towards international economic governance arrangements. How do we now make public health policy? Certainly doesn't look like the Westminster system, with the minister at the apex accountable individually and collectively to Parliament. Actually, scholarship, certainly public administration scholarship, knows relatively little about how policy making works, both empirically in these sorts of arrangements that have internationally economic governance arrangements alongside constitutional government. We know very little empirically. We also lack a kind of strong normative theory about how policy making ought to work in these sorts of areas. And part of the grant, at least for the purposes of public health policy, the now famous Domain 3 of the grant that we'll be working on over the next 3 years, actually scrapes away and tries to make some progress on these sorts of questions. How are public health objectives, concerns, voiced, represented and influential in policymaking in these kind of arrangements? Now I'm going to sketch, Sharon really did set me up by saying I've got the answer. I'm going to sketch a very brief answer. I'm not sure if I even agree with the answer, but I'll put it out there for discussion. And that relies on the notion of governance. Slippery, contested notion. I'm just going to sidestep 25 years or more of debates about quite what governance is and plough straight into the point that says agreements like the TPPA represent a shift of varying degrees from public governance to private governance, from forms of constitutional democracy through to increasing amount of power and authority in the hands of transnational corporations who govern through their internal management practices, through their relationships, through their distribution chains and supply chains. It's especially the case in developing countries. You could see that transition much more clearly. But what is the public role of private governance? How can we insist on that transnational corporations who are doing this governance are forced in some sense to acknowledge their place in the public realm? To the hot potato question of accountability that was thrown around early on and dropped politely to one side is increasingly relevant here. How do we hold private power to account in terms of the interests of public health policy? Now I'm going to suggest three mechanisms. As I say, I'm not entirely convinced any of them is persuasive, but these are the sorts of mechanisms that we'll be investigating through the grant. The three are a new form of transnational politics or political strategies, appeals to enlightened self-interest of corporations, and very briefly, international regulatory competition. So I'll say a little about each of those and then put them out for discussion. If we imagine that politics has shifted from domestic political institutions, that if you are wishing to advance our public health policy objectives in some other era, you would have tried to persuade political parties to put it as part of their manifesto, who would subject those manifestos through electoral competition, and whoever won would then be able to implement those. That form of politics in this hybrid public-private mixture fades away, and perhaps we need a newer form of politics, and it is obviously existing, we've heard that from several speakers today, which tries to act more directly on the corporations themselves and to try to persuade them to acknowledge their public policy role. And I'm thinking of questions of encouraging citizens to use consumer power. Consumption activity can be an expressive political activity. Fair trade, coffee being an obvious and an early example. That might be able to persuade Forestry Stewardship Council, Marine Stewardship Council, all these sorts of brands that corporations use to try and persuade people that they're being, in some sense, acknowledging their public role. Corporate social responsibility, is it anything more than PR exercise? Or is there something more substantial there that can be appealed to as a governance arrangement to try and solve this problem of accountability when you have these public-private hybrids? Elite business schools around the world have courses now on business ethics, have courses on what they call non-market strategy, about how corporations need to present themselves to society above and beyond simply their activities in individual markets. Can that be used as a way to try and encourage firms to acknowledge their public policy role? I'm sceptical, but it's something I think that needs to be investigated empirically, and through Domain 3 of this grant we'll begin to look at those sorts of questions. So that's the first mechanism. The second is an appeal to an enlightened self-interest. Is there some kind of self-equilibrating mechanism within our current form of capitalism? Do firms eventually realise that poor health and large health inequities is bad for business? It's bad for workforce participation, it's bad for workforce productivity, it's bad for consumers. And then maybe that will begin at some point to operate. Or is this simply too difficult to imagine? Or is it a part of different industries relating to each other through industry associations? Do they hold the key to force the worst offenders or the biggest potential risks, those corporations that pose the biggest potential risks, to force them into this public realm a little bit more? And finally, international regulatory competition. We've heard right at the beginning from Sharon about the increasing number of deep RTAs. And as these get deeper and deeper, and there are more and more of them, and they begin to interact with each other through key focal points like the United States' participation, the European Union's participation, China's participation, is that kind of regulatory competition between different forms of international trade agreements necessarily going to level us down? Or is there some potential to level things upwards, in which public health provisions are more clearly enshrined, capacity to deal with the risks that are posed? As I say, there's the three mechanisms that are somewhat speculative. I think they need to be investigated, though. I don't think we can just dismiss them as having no particular consequence. But I think they do provide one way of forcing public consideration, a public policy role onto private corporations, which, as we've heard today, would seem to have a greater degree of governance, authority and power under the TPPA. Okay, I'll finish there.